I mentioned Amy Remington. Amy is our general counsel for Landrum Companies. She's going to talk to us a bit about employment law and some of the changes that we're seeing in employment law. So, Amy.
Great. Good morning. We certainly appreciate you being here. My name is Amy Remington, and as Ted said, I'm the general counsel for Landrum Companies. And so what I spend a lot of my time doing is trying to stay ahead of the curve in employment law changes. And I'll tell you, I have never been so busy in my entire career as I have been in the past 2 months. I watched every debate. I thought I knew everything that was going on in the election, and I have been absolutely blindsided. And so I can't imagine how employers must feel with all these new laws and new legislative proposals. And we're going to talk about just a few today. Let's see. Okay. I've put up here a couple of the laws that currently affect employers. And I could probably add another dozen off the top of my head of the existing laws. But we're going to talk instead about some of the brand new laws, 3 that are actually laws, and 1 that's a piece of legislation that I feel like every employer should at least be aware of so that you can form an opinion and make a business decision on how you're going to handle these things. The first one is called the Lilly Ledbetter Law. And this is actually Miss Ledbetter. And this was signed into law, but the roots of this law go back to litigation. And what happened in this case is Miss Ledbetter was employed by Goodyear Company. And she worked for Goodyear for 19 years. And at the end of her employment, Miss Ledbetter alleged for the very first time that when I was hired 19 years ago, I was paid less than my male counterparts that were hired for the same position. And so she filed a charge of discrimination with the EEOC, which is the Equal Employment Opportunity Commission. And a charge of discrimination is the first step to a federal lawsuit for gender discrimination or any of the protected categories under Title VII. And that protects sex, color, race, religion, and national origin. And that says that employers cannot make employment decisions on those categories. Based on those categories, they have to make them for legitimate business reasons. And so Ms. Ledbetter, after 19 years of employment, said, back when I was hired, the male counterparts were hired at a higher rate of pay. And so for all of these years, I've been paid less. And so every time I got a raise, I was still paid less. And so she sought back pay going back 19 years. And the problem with this is that Title VII contains a statute of limitations. And what that statute says is that you have to file a charge of discrimination with either the state or the federal agency, whichever is appropriate, within 365 days of the date of the discriminatory action. And in this case, the discriminatory action was the decision to pay her a lower rate of pay. So the decision was made 19 years ago. So that's when the statute of limitations started. And the case actually went all the way to the U.S. Supreme Court for the interpretation of this Title VII statute of limitations. And the case law throughout Title VII's history has consistently said that the statute starts when the act occurs, when the discriminatory act occurs, and that each subsequent paycheck, even though the effect of the discriminatory decision may be felt in each paycheck because the paychecks are lower than they should be, that doesn't restart the statute. And so the Supreme Court said, Ms. Ledbetter, you may have been paid less for 19 years, less than your male counterparts. However, you're 18 years too late in filing your charge of discrimination. And I think that opinion all the case law governing statutes of limitation. Well, the legislative response to this in Congress was overwhelming, and it was immediate. And what happened was, on January 29th, the Lilly Ledbetter Fair Pay Act was signed by President Obama. And what this law says, it turns Title VII and the Americans with Disabilities Act and the Age Discrimination and Employment Act on its head. And it does this for employers. And so this is where the rubber hits the road for all employers. What it says is that if you have a discriminatory action and it relates to wages and somebody's not being paid correctly and they say it's because of a discriminatory reason, which is sex, color, race, religion, national origin, can also be veteran status, age, or handicap, for any of those reasons, every single time the effect is felt in a paycheck and a paycheck is lower because of the discrimination, the statute of limitations starts all over again. So in essence, with Ms. Ledbetter's, if you apply that to her case, for 19 years, every time she got a paycheck, the statute of limitations would start over again. It's problematic for employers because, again, it applies not only to Title VII and all those protected categories, it also amends the Age Discrimination in Employment Act, which protects employees who are over 40, and the Americans with Disabilities Act. So if your employee has a disability or is perceived as having a disability, it protects them as well. And it makes record keeping very, very difficult for employers. Traditionally, what I've always advised is that employers maintain employment records for about 7 years after employment ends, that you maintain all of an employee's records for the entire duration of their employment, plus about 7 years. And that'll cover you for IRS purposes and for wage and hour purposes. But under this law would seem to say that if you hire employee A and you pay them X dollars an hour, and then you hire employee B and you pay them Y dollars an hour, and A and B are in different protected groups, that as long as one of the two of those people is employed, you need to maintain the records on both. Because if you don't, and one of those persons files a lawsuit saying you've discriminated against me, you as the employer have to be able to articulate a legitimate, non-discriminatory reason for your employment decision. And if you've destroyed those records because, say, A's been gone for 5 years or B's been gone for 7 years, but the other person's still there, if you can't provide records to show why you made those pay decisions, that legitimate non-discriminatory business reason, and you won't be able to prevail in a lawsuit. So it's making record keeping for employers very, very difficult. One thing that we are advising our clients to do is consider going paperless with a secure system where you can maintain things indefinitely, because then at least you're not trying to store paper indefinitely. But the idea of maintaining employee records indefinitely is burdensome and overwhelming. So I think we'll see, because there's no case law on this issue yet, I think we'll see how employers are doing it as time goes forward. But for now, I would advise that if you don't have a record retention policy, that you get one. And if you have one, update it and make sure it's in compliance with this law.